We think we have a pretty simple idea of what it means to own something, right? It's mine, it's not yours. Simple. But what if I told you that the whole idea of ownership is really just a ladder of competing claims where saying something is mine is almost never the final word? Well, today we're going to dig into that and challenge pretty much everything you think you know about who really owns what.
Okay, let's just jump right in with a scenario. Picture this. You're walking down the street, and something glinting on the pavement catches your eye. It's a huge, sparkling jewel. You look around, nobody. You scoop it up. Now, the old playground rule kicks in, right? Finders keepers, losers weepers. But is that actually how it works? Is it yours?
Yeah, not even close. In fact, the law has spent centuries building this incredibly complex and honestly fascinating system just to answer that one question. That simple act of finding something, it kicks off a whole legal showdown of rights. And trust me, the winner isn't always who you'd think.
To really get our heads around this, we have to go way back, all the way back to 18th century London, to a case that basically became the cornerstone for the law of finders. And it all started with a chimney sweep and a very, very valuable jewel.
So here's the story. A young chimney sweeps boy is working, and he finds a jewel. He has no idea what it's worth, so he does the logical thing. He takes it to a goldsmith shop. The apprentice there pretends he needs to weigh it, but instead he slyly pries the precious stones out. Then he offers the boy a tiny amount of money for just the empty setting. The boy's not having it. He says no and demands the jewel back, but the apprentice only gives him the empty socket. So what happens? The boy, the finder, sues the goldsmith. So who do you think should win? The court's decision here was a total game changer. It ruled that the finder, our chimney sweep, even though he wasn't the true owner, had a better legal claim to that jewel than anyone else in the world except for that one true owner. And since the true owner was nowhere in sight, the boy's claim beat the goldsmith's hands down. This one case set the fundamental rule for all finders' law.
And this case is the perfect way to understand a core legal idea called relativity of title. See, ownership isn't some on or off switch. It's more like a ladder of rights. The original true owner, they're at the very top. The finder, the chimney sweep, he's on a lower rung. But, and this is the key, he's still standing on a rung above the goldsmith who tried to take it from him. Your right to something is always relative to whose claim you're up against.
Okay, but what about that person at the very top of the ladder, the true owner? Well, it turns out the law is super interested in what was going on in their head when they got separated from their property. And that adds a whole other fascinating layer to this whole question of who owns what. So this is where the owner's original intent becomes absolutely critical. The law actually sorts found stuff into 3 different buckets: lost, mislaid, or abandoned. Now, if something is lost, like it accidentally fell out of your pocket, the true owner still has the best claim. Same goes for mislaid property. That's something you intentionally put down somewhere and then just forgot about. The only time a finder actually gets to beat the original owner is if the property was truly abandoned, meaning the owner meant to get rid of it forever. So let's make this practical. That subtle difference between lost and mislaid is huge. A wallet falls out of your pocket onto the street, that's lost. Your laptop that you set on a coffee shop table and then walked away from, that's mislaid. And why does that matter so much? Because the law tries to do what's best for the true owner. For mislaid things, the property goes to the owner of the shop, not the finder. The logic is you're much more likely to remember leaving your laptop at the coffee shop and go back there for it than you are to track down some random person who found it on the street. This all seems pretty straightforward, doesn't it? If something's abandoned, the finder gets to keep it. But what happens when finding something means digging up a sacred burial ground? A really interesting case from Louisiana pushes that definition of abandon to its absolute breaking point. So get this. An amateur archaeologist named Leonard Sherrier finds and excavates this major historical Tunica Indian burial site. He unearths tons of culturally priceless artifacts, but when he tries to sell them, he hits a brick wall. He can't prove he owns them. So what does he do? He sues and makes this incredibly bold claim that the Tunica people who buried these artifacts centuries ago had legally abandoned them. But then, the modern Tunica Biloxi tribe steps in, claiming a right that's far, far older than his. And the court's response? It was powerful, and it completely shut down Sherrier's argument. The court established a really important principle. You can't abandon something you intend to keep safe forever. The whole point of burying objects with the deceased is to preserve them, not to throw them away. So burial goods can never be considered abandoned. The claim of the descendants always trumps the claim of the finder.
So we're starting to see a pattern, right?
A finder's right is pretty strong, but it can be beaten by a true owner or, as we just saw, by the descendants of an entire people. It just goes to show again and again that property rights are all relative. Which, of course, brings up a much bigger question.
We've seen finders and possessors and original owners all duke it out. But what's the ultimate source of ownership? I mean, what is the one claim that has the power to defeat every other claim out there?
Well, the answer is sovereignty, the power of the government. At the end of the day, property rights don't just spring up out of nowhere. They're created, they're defined, and they're enforced by a sovereign power. And there's no case that makes this clearer than a foundational U.S. Supreme Court decision about who owns the land itself.
So this whole thing revolves around a concept from the 15th century called the doctrine of discovery. Now, this was basically a set of ground rules that European nations made up for themselves to decide who got what in the Americas. It said that the first European nation to discover a land got the ultimate title to it, and the native people who had lived there forever, they were seen as having just a right of occupancy, which the European sovereign could, well, get rid of. This all came to a head in a huge Supreme Court case, Johnson versus McIntosh. Just look at this timeline. It's a mess of competing claims. You've got the Piankashaw Indians selling land to a group of citizens way back in the 1770s. But then later, the United States government, which had inherited Great Britain's discovery title, grants that exact same land to another guy, McIntosh. So you have two people, both holding a piece of paper saying they own the land. Which one is legit? So the Supreme Court had to choose between two totally different kinds of title. On one hand, you had the Indian title. It was a right to live on and use the land, but under that doctrine of discovery, they weren't allowed to sell it to private individuals, only to the U.S. government. On the other hand, you have the U.S. government's title, which it saw as the absolute ultimate ownership. It was the only power that could grant a permanent title that U.S. courts would recognize. The court's ruling was, well, it was blunt. Chief Justice John Marshall basically said that, look, regardless of how you feel about the original justice of it all, the courts of the conqueror are bound by the laws of the conqueror. Since the entire country's title to land was based on this doctrine of discovery, which is a form of conquest, the courts had to side with the title that came from the U.S. government. So McIntosh won. Not because his claim was more fair, but because his claim came from the sovereign.
Okay, so let's tie this all together. What have we learned? First, ownership is always relative. A chimney sweep's boy can have a better right than a goldsmith, but his right is weak compared to the true owner's, unless that property was really and truly abandoned. We've also seen that context is everything. You can't just go find sacred artifacts in a burial ground. And finally, standing above all of these individual claims is the massive power of the sovereign, the government, which has the ultimate say in who owns what.
And that kind of leaves us with this one final, lingering question. If every single claim to ownership is just one rung on a very long ladder, and it's always vulnerable to a stronger claim from above, and it's all ultimately controlled by the power of the state, what does it really, truly mean to say that something is yours?